Good morning. I would like to start by thanking the organizers for inviting me again and for facilitating my contribution remotely. I very much wish I could have been present for this great seminar on the freedom to choose, contracts, capacity in the law, and I think it would have been really great to be there to share more fully in the exchange of ideas and to learn from experiences of people with disabilities in the realm of contract law. I very much wish I could have been there, and I hope that there will be another opportunity in the future to continue the conversation on this topic. So let me start by giving sort of a brief outline of the presentation that I have that I will be giving today. So in this presentation, I would like to discuss the idea of contractual capability as somewhat of a replacing concept for contractual capacity, and proposing contractual capability as sort of a cornerstone for a contractual framework that really aims to enhance autonomy and freedom for people with disabilities. So I will aim to defend the idea in this presentation that in order for contract law to fully take on a autonomy enhancing task, it and we need to dissolve a hostility that exists between vulnerability and autonomy within classic notions of contract law. So in this presentation, I will briefly discuss sort of 3 points before moving on to a suggestion of various ways in which we can think of contract law as a capability enhancing instrument. So I will first say something about this hostility between vulnerability and autonomy. I will say something about why that hostility prevents contract law from providing autonomy enhancing responses to vulnerability. And I will say something about how we may want to resolve that hostility through a capabilities framework. So the last section actually of this presentation will be the main section in which I will discuss sort of 3 models for how we can envision contract law responses to vulnerability if they were autonomy enhancing. So let me start with that first claim about a hostility between vulnerability and autonomy in contract law. So contract law historically responds to structural vulnerability of people with cognitive disabilities by negating autonomy through contractual incapacity. So the denial of capacity is, of course, the legal response that is at the core of this project, and so I will not further discuss sort of the details of its manifestation in contract law. I will only provide sort of a brief explanatory account of why the denial of capacity, so contractual incapacity, has actually makes sense within classic contract law. So why does it make sense as a response in classic contract law to vulnerability? So my claim is that in classic contract law, vulnerability on the one hand and autonomy on the other hand are antithetical. The ability of individuals to independently judge and pursue their self-interest through contract underlies the degree to which contract law will support contractual arrangements that individuals will seek to make. So that is sort of capturing the core of the idea of autonomy that is ensconced in classic contract law, namely sort of an idea of independent judgment and self-reliance. And this is the notion of contractual autonomy that is central to questions of contractual enforcement and questions of capacity. Now, if we think of contractual autonomy in these terms of independence and self-reliance, then vulnerability in that context refers to the degree to which individuals do not live up to that ideal of autonomy as independence. So that is to say, the degree to which individuals are sort of perceived to depend on others in terms of evaluating, pursuing, and or protecting their own self-interest. So ideas about independence and dependence are thus central in the narrative, in the contractual framework, in the contractual narrative that we know very well in contract law. So people with cognitive disabilities often find themselves to be regarded by others as categorically vulnerable and not to be able to live up to this ideal of independence that is required for contractual autonomy in the classic framing. Now, contract law's response to vulnerability is then one of autonomy denial, namely of incapacity, because contract law's categorical assumption is that autonomy requires independence and sort of an independent judgment of self-interest. To the extent that people are presumed not to be able to give that independent judgment, they are presumed to be vulnerable, and so their vulnerability, if perceived as categoric, leads to a denial of autonomy. So this perceived hostility between vulnerability, let's say dependence, and autonomy, let's say independence, prevents contract law from providing an autonomy enhancing response when confronted with vulnerability. Because autonomy is understood as self-reliance and independence, vulnerability as dependence can only be perceived as sort of the absence of autonomy. So one way to resolve that is by looking at contract law through a capabilities lens. And this lens, through this lens, the claim is that contract law should enhance the abilities of individuals to choose and pursue their life plans through a contract. That is then the central aim of contract law. And capabilities conception of contract law then relies on the idea of autonomy not as not as independent self-reliance, but as sort of the idea that all persons experience varieties of dependencies and vulnerabilities that contract law navigates, and that contract law aims to support and seeks to enhance towards autonomy. So contractual capability tries to dissolve the hostility between vulnerability and autonomy by not referring to autonomy as the absence of vulnerability, but by thinking of autonomy as sort of the situation in which the abilities of individuals are sufficiently supported by law such that they can pursue their own life pursuits through contract. So in a way, in a capabilities framework, contract law is itself a response to vulnerabilities of all individuals, a response to a diversity of vulnerabilities that individuals may experience, and the response is at its core one of autonomy enhancement rather than autonomy denial. So now let me say something about the way we can approach contract law or conceive of contract law or future contract law and contract law reform if we think about its contract law's central role as autonomy enhancing. So what would autonomy enhancing responses look like if we were to consider vulnerability? In particular, vulnerability that may be experienced by people with disabilities. One helpful way to do that is to look at how contract law currently responds to other cases of contractual vulnerability. And so I will discuss now sort of three models as sort of proposals to think about how we could envision contract law in a capability enhancing way for people with disabilities. So three models are the assimilation model, the accommodation model, and a relational model. And each proposes sort of a different way forward as a response to the tension between vulnerability and autonomy that I've been discussing so far. So let me first say something about the assimilation model. It's the first model that I will discuss. And in this model, if we would advocate for it, we would try to sort of model the emancipation of people with disabilities after the way emancipation of other categories of people has occurred when they had when contract law historically denied their legal capacity. So emancipation in that in those cases sort of suggested that formerly people formerly regarded as contractually incapable now emancipated into the existing contractual system. By this I mean to say that contractual capacity was no longer applied and would no longer be applied, and instead the existing rules of contract law would just be applied as a system as it exists. So in the case of people with disabilities, this would mean we would stop applying the label of contractual incapacity and instead just refer to existing rules of contract law when in cases of contractual relationships that anyone would want to pursue, sort of. So existing rules of contract law, in other words, would be applied regardless of whether a contracting party is someone with disabilities or not, and would apply thus to all contracts alike. Now, if we pursue this assimilation model, then it's of particular interest to examine how existing legal remedies in modern contract law could offer safeguards against exploitation, for instance. So such legal remedies generally aim to correct severe inequalities between contracting parties. And in different legal systems, these remedies include rules on, for instance, undue influence, unconscionable bargains, on error, threat, and fraud, for instance, on duress, and on abuse of circumstances. So these legal concepts we can find across legal systems in Europe, and they each seek to correct severe inequality between parties. Now, the assimilation model is then the same model that has applied to, for instance, married women. So where historically they were subject to contractual, to the denial of autonomy through contractual incapacity, at some point they emancipated such that existing rules of contract law would just apply to the contracts they engage in. And so to those who advocate for this assimilation model, it would be important to examine to what extent the application of existing clauses of the sort that I've mentioned, so abusive circumstances, for instance, to examine how such a clause could appropriately support people with disabilities as they engage in a contract, and to what extent those clauses would in itself offer sort of a autonomy enhancing response. This model thus requires that we apply existing rules of contract law, which may have an emancipatory effect. It may signal respect and it may counter stigmatization, but a critical point must be made here, namely that we risk in this model sort of presenting freedom as a formal type of freedom rather than a substantive type of freedom. And by this I mean that even though we may achieve equality in the realm of legal treatment, we might have an unequal outcome when it comes to the real ability to pursue life plans through contract law. So, in short, the assimilation model sort of advocates for rules of contract law to be the same across all contracts. Its implementation requires not much change. It just requires that we stop applying the category of legal incapacity to people with disabilities in the realm of contract, and otherwise apply existing rules of contract law to contracts, regardless of whether they are entered into by people with disabilities or not. So that is the first model, that is the assimilation model. Now let me move on to the second model, which is the model that I refer to as an accommodation model. And if we were to pursue that model, we would have to advocate for special autonomy enhancing rules of contract law that apply only to people with disabilities. And so this is sort of the model that contrasts most with the assimilation model, because under the accommodation model, we could think of a wide range of rules that we have to develop, that we have to enact in order to offer special support to people with disabilities in order to enhance their autonomy. Now, if we want to pursue such an accommodation model, it is of particular interest to examine how and if existing contractual responses to other sorts of contractual vulnerabilities may offer inspiration. So let me take as the example consumer protection. So consumer law offers legal protections to a variety of consumers. So whereas historically consumers were perceived as sort of a category of vulnerable contracting parties, we now see under the European legal framework that there's actually diversity of consumer images. Some of those images, for instance, include the average consumer, a vulnerable consumer, and consumers whose characteristics make them particularly vulnerable. So we think about these latter two categories, vulnerable consumers and particularly vulnerable consumers. The rules that apply to them could offer sort of inspiration, as they already currently aim to capture characteristics such as age. So it includes consumers who are elderly and who might have particular vulnerabilities when they engage in modern market exchanges. And it aims to include people with cognitive disabilities currently, and includes or aims to sort of prevent and protect people with disabilities from a particular type of market exploitation to which they may be particularly vulnerable. So those who advocate for the accommodation model, as opposed to the assimilation model, should sort of examine what sort of special protection and distribution of rights and obligations would be appropriate to achieve a level of autonomy enhancement that is desirable for people with disabilities. So we will need to think about developing and applying special rules of contract law that can enhance substantive freedom, and in doing so, this sort of claim towards or move towards the creation of special rules risks stigmatization, of course. And so the assimilation model and the accommodation model sort of are each other's mirror, in that the assimilation model risks not achieving substantive freedom, but sort of avoids issues of stigmatization. The accommodation model may encounter claims of stigmatization, but is more likely to achieve appropriate levels of substantive freedom. So in short, we have now the assimilation model that sort of advocates for applying contract law rules across the board similarly to all contracts, and the accommodation model that advocates that there should be special rules that apply to people with disabilities in order to pursue and enhance their autonomy specifically. So then there is a third model that I would like to discuss, which I refer to as a relational model. And for those who pursue a relational model, we would have to advocate for sort of a reconstruction of existing legal norms entirely. The relational model requires that instead of taking people without disabilities as sort of the norm, so think of the way in which contract law currently refers to autonomy as independence and self-reliance, that is contract law's norm currently. The relational model would ask that we move away from that norm and ask how the law can actually deal with contractual relationships between people that have various levels of vulnerabilities, whether they are people with or without disabilities. So the relational model moves away or takes sort of a different direction than both the assimilation model and the accommodation model altogether. So the central question for the relational model is how can the law facilitate contractual relationships rather than contractual parties into sort of a desirable outcome. So if we were to pursue the accommodation model, this would require us to rethink how rules of contract law and rules of general contract law should look like if we take into account the diversity of human vulnerability as a norm. So this may result in a recommendation that radically reconstructs contract law in order to facilitate contractual relationships between people with a wide range of diverse vulnerabilities. So in this model, it is not immediately clear to what extent or sort of what this would mean for contract law as it currently looks, and the extent to which legal systems would have to be adapted. But my hypothesis is that given the degree to which current rules of contract law are founded on the assumption of autonomy as independence, the relational model would sort of require a radical change, I suspect, rather than some minor modifications or the implementation of, for instance, some special rules. So I think for those who would advocate for a relational model, we would have to examine what sort of contract law rules could facilitate contractual relationships between people with various vulnerabilities, regardless of their whether in other settings we would refer to them as people with or without disabilities. So, say the assimilation, the relational model will have the potential to result in a proposal for a legal regime that is autonomy enhancing for all, for everybody, regardless of specific forms of vulnerability. But the critical point for this model is whether it is feasible and practicable if such a proposal would indeed result in very radical changes to contract law regimes as we currently know them. So to conclude, I've sort of aimed to show that vulnerability and autonomy are antithetical in classic contract law, and that there are at least 3 ways forward for us to dissolve this hostility between vulnerability and autonomy in the way that a capabilities perspective would sort of require. So if we think of contract law's main purpose to enhance the abilities of individuals to choose and pursue their life plans through contract, and we also assume that individuals are have diverse vulnerabilities, then there are at least 3 ways forward to think about what this would mean for contract law reform. The assimilation model, again, would require the application of contract law rules as they exist. The accommodation model would require the implementation of special rules for people with disabilities, and the relational models would sort of require that we rethink radically what underlying assumptions we make about contracts and about who is the underlying norm. The relational model would require us to look at the sort of relationships we want to facilitate between people with various vulnerabilities, regardless of whether they are people with or without without disabilities. So as we've seen, each of these models also encounter potential criticism regarding the failure to achieve contractual capabilities, that is substantive outcome. In the case of the assimilation model, we encounter criticism regarding stigmatization or potential stigmatization in the case of the accommodation model, and we encounter critical notes regarding feasibility and practicability in relation to the relational model. So I think it would be productive to see whether the sorts of support that people with disabilities would consider autonomy enhancing, whether they would map onto any of these models as I've presented them, whether they would map onto, for instance, existing legal protections as they already are in place in general contract law, or whether they would map onto existing responses to particular vulnerabilities, for instance, in the area of consumer law, or whether they would require radically different sorts of protections that the law and contract law currently does not offer in general contract law or any of its specific areas to begin with. And so with that, I would like to conclude and thank you very much for your attention. I would have loved the opportunity to answer questions and to discuss further how the three models that I put forward might be a help in thinking towards future legal reform in the area of contract law. But again, I hope that that opportunity will present itself in the future. So thank you very much for your attention.
And we'll hear from Michelle, who is doing a doctoral research and exploring the practice of supported decision making, and has been involved in trials in this area, which is hopefully will be really informative in terms of where we're going with our legislation and our planning. Thank you. Now, Paul.
Good morning, and thanks you very much for having me here, everyone, today, and for coming along to listen. I was 19, going on 20, when I moved into Peamount Hospital on the 19th of April 1983. I didn't have any else to go, so I called a social worker who got me a bed at Peamount Hospital in Newcastle, County Dublin. The social worker told me I would be at Peamount for 6 months. It took me 32 years and a half to leave. Today I want to tell you how I left Peamount in January this year and moved into my own house. I don't remember ever living with my family in East Wall, Dublin. My brother Jimmy told me I had bad health as a child and was in and out of hospitals a lot. After some back and facial surgery, I had ended up staying at St. Mary's in Baldoyle, run by the Daughters of Charity. At the boarding school, I was forced to do things I didn't want to do. It was hard life. I stayed at Baldoyle until I was 8.5. After Baldoyle, I went to St. Augustine's School at Oblis Park, Blackrock, run by the St. John of God brothers. It was 1972 and there was only boys living there. In 1979 I started doing work experience and trying different jobs like a bakery assistant, supermarket assistant, a store assistant and horticulture assistant. My favourite job was working in a SO garage, sweeping the floors and doing cleaning. I left St. Augustine's School in 1981, nearly 18. I got a job at the St. John of God's nursing home in Kilcrony, Bray, County Wicklow. It was a home for old people. I did things like washing dishes, working in the laundry and cleaning bedrooms and tidying up. I was unhappy with the wage and hours. At St. Augustine's School, I visited the force in Bray and landed a job as a trainee kitchen porter at the Glenview Hotel in County Wicklow. I had my own room for 6 weeks, but unfortunately I couldn't stay because they told me I was too slow at the job. I was scared I would end up homeless, so I contacted the social worker back at St. Augustine's and she arranged a bed for me at Peamount Hospital as a temporary arrangement. Had the job at the Glenview worked out, I think my life would have been very different.
And obviously that's important to start off, and now we're just moving on to his own home, his own life.
Right.
Thank you.
Yeah. I loved travelling. When I moved to St. Brendan's, the staff told me I couldn't go out on my own without permission. I told the staff I had a holiday booked to the Isle of Man because it was paid for. They couldn't stop me. The staff had meetings about me. I wasn't allowed to attend them. In the end, they agreed to let me go and I had a great time. They told me, "You should tell us before you book any holidays." I choose to ignore their advice. When I lived at St. Brendan's, my mom and dad would visit on Sundays. We had a chat and a cup of tea or biscuits. Once every blue moon, my 3 brothers and sister would visit me. I had to get permission to leave Peamount and visit them at their home in East Wall, Dublin 3. When I got to visit them, I would catch the bus and take my dad the Irish Independent newspaper and my mother custard creams for afternoon tea. In 1985, after my first 2 years in St. Brendan's, I moved to Pine Lodge, which was one of the bungalows at Peamount. I lived with 9 other people. In 1990, I moved to Aylmore Road, a residential house where I learned to cook, wash my own clothes and clean. Meal times were still at the same set, and I had to go to bed at 10 p.m. every night. I shared a room at Aylmer Road with one other person. When I lived at Peamount, I had no choice in the work I did. We all had to work in sweatshops. I had 2 different jobs over the years. One was packing empty whiskey bottles in cardboard boxes. The other job was tying up mushroom baskets and covering them with shrink wrap. The supervisor of the workshop was a bully. She wouldn't let me go outside to have a smoke. I enjoyed smoking cigars. Now I smoke a pipe. She would time people when they went to the toilet. If someone was late, she would ring their house and threaten them they wouldn't get money. When I worked there, I was paid 10 pence a day, which was 50 pence a week, for working in the workshops. When I lived at Peamount, they took my disability allowance and only gave me 20 or 30 euros a week out of it. In 2005, the law changed and people in institutions could get some of the money owed to them. My friend from Inclusion Ireland, Lisa Kelly, helped me get back my money back. It took 3 years. In 2008, they sent me a big check that I put into the bank. I decided I was going to use that money to buy my own apartment. At this time, the staff at Peamount started taking me to self-advocacy meetings once a month. At one of these meetings, I was invited to become part of an anti-bullying group run by the National Institute for Intellectual Disability at Trinity College. I didn't know when I joined the group that the support I would receive there would become very important in my future. At the anti-bullying group, I was approached by Inclusion Ireland to be on the RTE 360 programme on television. They wanted to talk to people who had disabilities in Ireland who lived in institutions. After the interview, I was offered a job at Inclusion Ireland. When I started at Inclusion Ireland, I made mistakes like sending letters to the wrong people because I didn't know how to read or write. I did not get a proper education. Inclusion Ireland helped me find a course that would teach me how to read and write. I attended classes for 2 hours each week, yet before work for 7 years. I can now do my job well. And then that was the college up in Mountjoy Square for the learning people, with adults, and then there was a few learning disability people as well. It was called the Adult Learning Centre. Yeah. Want me to go here? Yeah, that's sure. It took a long time for me to be able to move out of Castle Lines because I wanted to own my own home. The staff at Peamount kept suggestions of opinions I didn't like. For example, sharing with other people and renting instead of buying my own place. I said no. I wanted to live by myself in a place I owned it. Yeah, right. This one. What is it? Yeah. I went to a meeting with Peamount with my boss. I went to a meeting with my boss from Inclusion Ireland to talk about getting my own place. The people from Genio introduced me to Dr. Bob McCormick from Possibilities. He organised meetings with Peamount, the staff at Peamount, to make a plan about moving out. Fiona Weldon from the anti-bullying group came to help me. Claire Finnegan from Possibilities also had a lot to do with supporting me to move out. My brother Jimmy and his wife came to their meetings. They were nervous about me moving out, but I said it was my life and I wanted to move. Once I had the money, it also took time to find a place that was in the right location at the right price. It needed to be near a bus route in a safe area, have shops and not cost more than €80,000. I found my own apartment with the help of my friends Jim and Fiona in a small town in County Meath. I moved into it after some renovations on the 11th of January 2016. I really enjoy living there on my own. I get support from Brian, my direct supporter worker a few times a week. I see my friends Jimmy and Fiona twice a week. These people help me to do things I can do on my own, like book holidays and buy a phone. It was hard when I first moved into a new community. It was difficult to find things to do. It was only living by myself for the first time. I got support for 8 hours a week from Brian in the beginning. I asked him to help me to go to know my new community. Yeah. What? Yeah, right. We'll skip this and the last two. There's just two more. I learned how to do lots of things like cleaning my apartment, cooking and baking, learning how to change a light bulb and butchering. I like being busy and knowing what I am doing each week. I started arranging my own doctor's appointments. I have found living on my own as being good for my health. My blood pressure is not high anymore. I don't feel stressed. I feel much happier now in my new life. I see more of my brother and his family. We went away together to Graceland this year because I love Elvis. I feel lucky to have great friends, so live close to my new home, and others are further away. I speak to them on the phone. I think it is important that people with disabilities can do things they want to do. They should be able to live where they want to live, with who to live with, the support they need. Thank you very much for listening. Now, thanks very much for listening. I hope you get something out of the course today. Thank you to Charlotte, Eleanor, Fiona, Stephen and Michelle and Tina for helping me prepare my story. Have a good day, everyone.
Thank you. Thank you, Paul. And Paul, if you come back down here, thank you very much for that. We're now going to hear a short video from a doctoral student, Michelle Browning from the University of Trove in Melbourne. And as I mentioned earlier, her area of research is into assisted decision making and how we can make that work.
Hi, I'm Michelle Browning, and I feel privileged to have had the opportunity to get to know Paul Alford through my involvement with the Voices project. It's been a pleasure learning about his experience buying and moving into his own apartment this year. When I reflect on Paul's story, I feel encouraged and challenged. Encouraged because his story is one of triumph over tremendous adversity. And challenged because the many barriers that Paul faced in his journey to owning his own home were unnecessary. and still exists for many people with cognitive disability all over the world. The focus of the seminar today is reflecting on contracts, capacity and law, and I'm very sad that I'm not able to be there and attend the seminar in person. I think it's important to reflect on how the law shaped Paul's ability to live where he wanted and with whom he wanted. Interestingly, it was not Paul's capacity to contract that kept him from buying his own home for many years. The most significant barriers were the beliefs and expectations of the people who were supporting him. The staff at Piedmont did not believe that Paul had the capacity to live on his own, and as a result, it prevented him from being able to try. He was not thought of as someone who could contract. In spite of managing his own money, travelling independently within Ireland and overseas, and having an excellent credit rating with his bank. But the law did assist Paul to buy his own home. A change in the law in 2006 was a key enabler in him and in his story. The Health Repayment Scheme Act was created to enable people like Paul, who had been charged unlawfully to live in institutions over many years, to get their money back. So when Paul received a large lump sum of money as redress, he used that as a deposit to purchase his home. Without the introduction of the Health Repayment Scheme, Paul may have never been able to afford to purchase his own home. There were many environmental barriers that made it difficult for Paul to move into his place. Some of the barriers he made me aware of include poor access to quality education and literacy, limited opportunities to learn about his rights and develop the confidence to speak up when he felt his rights were being ignored, a lack of services to provide practical support in finding a home, limited opportunities to manage money, develop financial literacy and a credit history, and a lack of poor quality social housing. I think Paul's tenacity and determination to never give up, to take every opportunity and to learn new skills allowed him to overcome so many of these barriers. Sadly, the greatest challenge that he faced was one that he had little control over, the attitudes and limited beliefs of others who were in positions of power. I believe for Paul, gaining the freedom to choose his own home was brought about by challenging the attitudes and beliefs others had about his capacity and finding people who would help him develop the skills he needed to exercise it. The law has an important role to ensure it is accessible to all people, and where there are injustices such as unfair payment for work or unlawful charges in relation to accommodation, it holds individuals, organisations and governments accountable. I hope the presentations and discussions that you're taking part in today are fruitful in exploring how to overcome the environmental and legal barriers people with cognitive disability face in exercising their freedom to choose where and with whom they live. Thank you.
The storyteller, Mr. Dermot Lowndes, and the respondent presentation is Mr. Jan Strand. Now, Dermot is also involved with Inclusion Ireland. He has had a high profile in relation to the campaign of the Right to Love. He was on the panel with Senator Zappone and is a member of the National Platform for Self-Advocates. That's right. And he is followed then by our speaker, Jan Strand, who is from the Czech Republic, a lawyer practicing in the area of disability and service provision, and he's going to be the respondent to the story. Thank you. So now, Dermot, I'll ask you to go ahead, both of you.
My name is Dermot Lowndes. I lived with my sister and my mother in 2020, and my mother died in 2020. So my sister, 2001 I mean, sorry, so my sister said to me, when my mother died, she said to me, you better start thinking about moving out. So I said, well, my mother's will wasn't read. How do you know you have the house and might be sold? So we had a little bit of ding-dong, said a lot of fighting and a lot of arguments and a lot of difficult. So I moved into this house. It was called Independent Living. So it was okay for a couple of months, and then I went really bad down. I done a few mad things. I wouldn't like to say what I've done, but that's not here or there. So then my sister from Cork went, and we were waiting for a year to see my mother's solicitor. When you were in Ireland and you have a disability, your parents are not told about the law for people with disability. They don't know what to do. They get wrong legal advice and they get wrong legal thing. I think people with disability should be left property if they're capable of living on their own, because the organisations like I'm in, St. Michael's, are okay, but they don't give you legal advice. They say, oh, that's family. So when you go and see a solicitor in Ireland, and he's gone, like, he's saying, oh yes, I'll meet you in the High Court, and you see people with handcuffs coming into the High Court, and you have a disability, and maybe the body's looking at you, well, when is your case coming up? And you're going, oh, I'm not here to go to court. I'm here to see my solicitor. So he brings you, he talks to you, oh, I'm carrying out your mother's wishes, that's all I can do. And you see, they do have a disability. But I can't get involved in a person with disabilities because I got involved with something else, blah, 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 he goes to me. And I got, right, well, my sister came with me from Cork and we went to Dublin Castle. So we went to see this woman, comes out with a big wig on her, and she's like the one that was dressed for Halloween. And takes out this big file that a lady, that man like me with disability does not understand. And then she talks about how to sue your sister. I haven't got fucking money to sue my sister. And the other sister hasn't got money. And my organisation didn't give me advice. So I don't know where I just went, what? Explain that to me. She says, this is the Constitution in Ireland, and this is since, I think, 1916, there's some law, and blah, blah, blah. She went, right, now that's it. Oh, yes, Mr. Burke. Now give the two people advice what they can do. And she goes on. So he says, well, here you go now there. You with disability, you know, and, I sent a letter to your cousin, and I sent on the bill, and you can sue your sister now, and your sister, and you can go to the High Court on it. And my sister from Cork said, I don't have money to do it. And Jamie doesn't have money. Would you please send the bill to us? So when we got everything out of my mother's estate, I got checked all out. I got, I think, €200 when all the bills and everything was taken in. And I think a person should be left the house and the law should be changed. And I think that they're talking about, the government are talking about independent living, like Bailey Harrison, the other minister, he talks about 2 million. So thank you very much and good. Bye.
Very clear message there, and now we'll have the response from Jan and go ahead.
Well, as you could hear, it's not easy. Is a task to reflect their work, because he is very clear about what he wants to say and what is he coming with. We joined this contract group as a last passengers, and we are at the early stage of our cooperation. But we spent a few hours discussing the story. New story for me, and there are some obvious points that we agreed to start with. Well, there's a problem with heritage, which is not understood to be contract in a strict sense, but there was wish to enable people with disabilities to inherit property in succession in their family. Is now a part of law in force. Article 12.5 CRPD is very clear in this. It's the obligation of state to ensure that the right of people to inherit property and not to be prevented in this, deprived of it liberally. Is now reality. The second question is, of course, that in the time critical for the story, CRPD was not enforced. In fact, it didn't exist at all. But even the National Irish Law Act on Succession of 1965 did not constitute particular obstacles for people with disabilities in real succession. So the solution that was taken about the will of Dermot's mother was not probably, and of course we have to discuss this with Irish practitioners, but from general point, this was not shaped clearly by law, and it was based by the lack of communication, maybe by the abuse of circumstances at the time, and which is very important in this. Even the present obligations of state lay in their basis in the offer of proper support to enable people to execute their rights, even in the questions of inheritance. This is what seems to fail completely in Dermot's case. Yeah, he tried to mention what was the quality and what was the form of the legal advice, legal support he obtained in this critical moment of his life. So this is something that we really need to address too. And the second point is the clear connection between this topic, shaped by Article 12, and Dermot's present situation in seeking for life on his own. Of course, independent life, one of its important bases is always property, whether you can afford it or not, whether you can afford to get appropriate support or not. That's an important question, and that's also the second point we would like to address too. Maybe I would like to ask Dermot, where do you see the main obstacles in your situation? What do you think
Because
prevents you most from independent life?
Your parents think that because you have a disability, that you don't understand the law, right? That's one thing. And when your solicitor is doing the law and all, it's not too clear because the solicitors don't talk to the disability patient. They're not talking to you. They're talking to your sister. They're not talking to you because you have a disability. They don't, but they waffle on that they let on to you that they went to court and that they got sued by some other person. Well, if you got sued by some other person, you shouldn't have been my mother's solicitor. You should be thrown out the legal right if there was legal right now. But that's why he told me and my sister. And then he wanted me and my sister to go to court. Should I have no money this year? I have to pay the rent in St. Uncle's house. So where would I get the money? Would St. Uncle's house give me money to sue my sister? They gave the granny or the government. So therefore, solicitors want to get trained in disability, I think. I know a person that can't, has found disability, he'll have to go into care. But if the government are talking and waffling on, and the HRE are waffling on, and we set all this plan, they have no plan, because I was on a meeting, and they're supposed to set up this independent living with HSC, hot, doctor, nurse manager on call, nurses, and there's no plan. So it's great to do the top talk, but it all goes into paper and goes into file. And they say, oh yes, we'll take that out in 10 years' time, and remember that. So thank you very much. And I feel strongly that solicitors are crap in Ireland.
People with disabilities to represent themselves in court.
What?
We have a system available for people who have legal experience and training, but not practicing solicitors and barristers. They're called Mackenzie's Friends.
Yep.
I'm one of those in Ireland.
Okay.
As a social worker that's been legally trained and comes with disability, I represent.
Well, I didn't get it.
Okay, so we just let Jan conclude your presentation first, and then we'll open to the floor for questions. We're finished with that? Okay, so well, thank you very much then, Dermot and Jan, for that, and Paul and our colleague from Melbourne. So now just to recap and to think, just to recap just for our questions, obviously we started off with a presentation from Dr. Lynn in relation to contracts vulnerability, and vulnerability in terms of entering a contract is nothing new to the law in terms of you have to have a capacity as the law requires it. We then moved on to the presentation from Paul.